Good afternoon, everybody, and welcome to another episode of the Wednesday webinar with Property Law Alliance. Hoe gaan het, Cilna? How are you?
Goed, dankie. Hoe gaan het met jou?
Lekker, man, lekker.
I was so surprised. I was so surprised. I've actually been sitting here translating the TPN leaseback from English to Afrikaans. So I'm like, my brain is ready to switch between English and Afrikaans, but it was a little bit of a surprise coming from you. Maar baie lekker, dankie.
Here's another surprise. Boa noite, Bruno. Como está?
Estou bem, tu?
Bruno, have you been translating anything into Portuguese recently?
No,
apart from your thought?
I haven't. It's Portuguese legal is like it's on a world of its own. No,
it's like Afrikaans legal, my friend.
Yeah.
It's not fun.
No, but welcome, everybody. Welcome to another episode. And it's so good, as always, to have our experts with us, Bruno and Cilna. We've got a jam-packed session for you today. So I think let's get straight into it. Oh, also, I just wanted to find out, I hope all of you have had a great weekend, a long weekend. I forgot to ask, slipped my mind. Cilna, how was your long weekend?
Amazing, thank you. I was sick in bed, which is now a good way to start this. If I suddenly switch off my mic and my camera, it's because I went into an amazing coughing situation. So I've been sick. Thank you very much. I went for a COVID test, tested negative, but pretty impressively sick. So in bed, and I binge watched, I'm not proud of this, but basically the entire Superstore, all 4 seasons that happened.
Yeah.
Sounds very productive.
So productive.
Bruno, how was your long weekend?
It was good. Not as good as Cilna's. That sounds like a proper break. Like I wouldn't mind sitting in bed watching Superstore.
Amazing.
No, but it was cool. No, we went away over Saturday night. I just got into nature a little bit, switched off the phone. I haven't done that in like a year and a half, so it was good.
Nice, man. Nice. Cilna, I hope that you get better and that you will stay with us during this. No cough attacks. I'm putting it out into the atmosphere now. No cough attacks on your side. Brilliant. So we've got our first question by a viewer of ours who was 9 years old when his parents were evicted from their home. He believes there was fraud in the site, but this was years back, which will come into play as I progress with the question. So he believes that there was fraud somewhere along the line, either on the bank side or whether it be with the deeds office. And I think what we want to find out here is if there is fraud or was fraud, especially on the side of the deeds office. So if you believe that you own a home, and then someday you go and you check at the deeds office and discover, oh, this home actually doesn't belong to me, it belongs to David down the road or somebody else for that matter. The belief is that what the deeds office says is the case. That's it. There's no arguing with the deeds office. So that's the first part of the question. And the second part is, what about prescription? Because like I said, this is a very old case. It happened a long time ago. What about prescription? How would that come into play in picking up with regard to this fraud? So Cilna, I'm going to quickly throw this one to you. Bruno, thereafter.
Brilliant. So Chris, it's a really interesting question. I think I've seen it a few times on the page. I think it's the same viewer. So I think we do have a bit more detail than our typical questions. So the situation is, the rule is, and this is a Dutch law principle that's been around for basically ever. And the simple rule is, whatever the deeds office record, that is the possession. So if you do a deed search and you see the property belongs to Miss C.P. Steyn, that is who the property belongs to. Never ask what the P stands for, but then the property belongs to me, and that's the way it is. Unless you can prove that there was actual fraud, but you need to be able to prove this. And unfortunately, remember, the moment we start talking about fraud and things like that, even in a civil context, even though your burden of proof is still less than in criminal proceedings, you still carry a very heavy burden of proof. So it's not just unreasonable probability, At least it's not complete beyond reasonable doubt, but still you need to show more than just there could have been, there might have been fraud. And the truth about this is the prospects of success are very low, because especially at the time, if we look at when this fraud must have occurred, it must have been in the early 80s, late 70s, early 80s to middle 80s. And at the time, there weren't as many transfers done as we are currently seeing. Remember, only about 10% of the population at that time were allowed to own property. So the kind of transfers, the volume that we're talking about in comparison to what we see in the deeds office today must have been about, Bruno, do you agree with me if I say about a quarter or less of what we are currently seeing? And why this is relevant is, especially in that time, now is very similar, but even more so than your registrar of deeds went through, and still do, but then he had more time to do it even more so. Go through the documentation with a fine-tooth comb before a property is transferred. And it's the reason why it's such a painful process. And remember, last week we spoke about why can't we transfer documents without physically signing the actual thing. And then we said, oh, yeah, but remember, it's so archaic. Okay, but now round, full circle back to, yes, but that prevents fraud. And the truth is, and I'm so sorry to be this blunt around this situation, the potential risk of truly proving that a property was transferred fraudulently is very slim. Not if it was fraudulent. If there was a fraudulent transaction, somebody was bribed and, you know, the property was transferred, and you are able to prove it, easy-ish, not easy, but easier. And the truth is, if we talk about something that happened that long ago, your witnesses, your expert witnesses, honestly, I can't see how you would be able to prove it. But one step further, and Bruno will go all the way around to the prescription, but something more important is, if the viewer was a 9-year-old boy, he didn't have any right or title to this property, even in a situation where later in future he might have, or he could have been, a title holder of this property. So what I'm saying is, even if the property was bequeathed to him, for instance, in a will, and his parents are now deceased, even in that situation, that fraud or alleged fraud, unfortunately, he can't be a claimant, he can't be an applicant, because he does not have locus standi, meaning he doesn't have the right to approach a court for these proceedings. So just on that, I can't see any prospects of success, and I'm truly sorry for our viewer. I do realize that you really want to get something done on this, and I realize that you do feel like doors are being slammed in your face, and I think it's important to really get the message across that one of the biggest reasons for that is I can't see that you have locus standi, and I cannot see that we can show in any way that you were prejudiced due to this. Yes, if you're 9 years old and you go through an eviction, it's absolutely traumatic, and I appreciate that. But unfortunately, that's not sufficient grounds to vest locus standi. But prescription is a much bigger and more stop you in the tracks problem. So over to you, Bruno, to just make it even worse.
Sure. Look, it is quite a sad scenario. And I mean, as you guys know, I used to do a lot of work in the sale and execution space. And I experienced this quite a lot, because typically you find that people losing their houses, properties getting sold, especially on foreclosures. There's very, very often a story behind it. Sometimes admittedly, the stories aren't legitimate or aren't true, but sometimes they do feel true. And you do see that they jump over hurdles to try and get things sorted out, and it's not always possible. So I have to agree with Cilna over here. The problem is it's the causal link. We're too far apart here. The locus standi is going to be an issue because the fact that your parents own this property does not mean that you would have owned it. Even if everything had gone smoothly, there's no guarantee your parents would have kept it. There's no guarantee your parents wouldn't have sold it and utilized the money or bequeathed it to somebody else. So that's already the problem. Is over here, we're speculating on what could have happened had they retained the property. If we're speaking about an eviction now this ties into both locus standi and prescription. If we're speaking about an eviction, it sounds to me like this wasn't an unknown event. And why this is very important is prescription. There's a whole bunch of rules when it comes to prescription, but one of them is knowing that the debt actually exists. So reasonably knowing, not closing your eyes and hoping that it didn't happen when in fact it did. So if you get a summons from the bank, but for some reason you don't hear from them in a couple of years and the property gets sold on auction and you didn't know about it, it's very difficult for you to go back and say, well, how would I have known? Because reasonably, once you got the summons, it's fair for someone to expect you to have asked further questions going, what happened after that, right? In a case like this, if you're evicted, the reality is that the event took place. Something at that moment went wrong. And that is typically the moment of realization that goes, okay, wait, something needs to be done. Now, it's true, as a 9-year-old boy, how would you know this? And prescription for minors, that it is wonderful because it does basically postpone it from applying up to a certain period of time. But now, again, this is where the problem comes in. First of all, when you became a major, you would have had to do something. And that unfortunately hasn't taken place from the sounds of it either, because it's been many, many, many years after that. But the reality is the claim was never yours to begin with. So how are you supposed to act on this claim and defeat prescription, saying that you were the minor and it was your claim? Your parents were evicted alongside you. So unfortunately, the reality of the case is that your parents would have had that claim. And they would have had to exercise it. And the prescription typically, when it comes to transfer of assets or claiming the transfer of property or whatever the case is, whether it's movable or immovable, is 3 years, right? It's the same as claiming a debt. So this is in terms of the actual legislation. They would have had 3 years to enforce this. If they didn't act within the 3 years, I doubt anything could be done, because most of the exceptions to prescription are things like people being out of the country, the debtor being out of the country, or there being some kind of acknowledgement of debt where the person acknowledges that the property should be transferred back, and they did it within that specific period of time. So unfortunately, putting all of this together, locus standi is going to be an issue because it wasn't your right to begin with, like Cilna mentioned. And then the fact that no one acted within 3 years of having knowledge of the fraud to begin with is the second problem. I know that Cilna, your one solution here was possibly to pursue criminal charges, but yeah, like we discussed before, it doesn't seem to be possible. Do you want to touch on that?
Yes, I think it's a good conversation, because I think it's important. Many crimes. So I just full what's the word I'm looking for? Disclosure and indemnity. Yeah. Neither one of us are criminal attorneys, and the honest truth is, I once brought a criminal case while I was doing my articles to the point of plea, and then I was like, okay, dankie julle, I'm out. So I have no idea. I don't practice in that field of law. I don't really. I try to avoid it as far as I can. But we quickly brushed up on our criminal law stuff, and I remembered, and there was something in the back of my head about criminal matters also prescribing, and we were indeed accurate. Big crimes, for instance, murder. Yes, we actually do have crime categories. It's not like sin. You do have bigger and smaller crimes. But look at me now getting all, explaining criminal law here. But you do have very serious crimes and then lesser serious crimes. For instance, you can't compare murder to shoplifting. So fraud, unfortunately, depending on the type of fraud, usually doesn't count as a serious crime. So it doesn't fall like with murder, rape, assault with the intent to cause grievous bodily harm, things like that, doesn't form part of that. It also doesn't go and sit with shoplifting, but it's sort of in the middle there, where it's not a super serious crime that cannot prescribe, and your criminal prescriptions in South Africa is typically after 20 years. And so if you haven't instituted proceedings within 20 years from the event, or even if you can argue from the time you became a major, and I would believe that if my calculations are correct now, and apologies if I don't mean to insult you here, but I think in your days, the majority age was still 21. I think it only changed in the early 2000s, eh? We changed to 18. But then if it's 20 years, if it's less than 20 years from there, maybe that's an option. But once again, you can't be the complainant in a criminal case if you weren't the party who's, especially in fraud, whose assets been dealt with. So if you never had ownership of the asset that was transferred fraudulently, unfortunately, you can't be the complainant in a criminal case either. But so 20 years prescription on criminal matters, not serious crimes. Serious crimes you can pursue lifelong. And the list of who's what that we're not going to discuss, because I'm probably going to step with my foot straight into my mouth. So I'm going to avoid that. But definitely fraud would fall under 20 years. Did I sound like a criminal lawyer, Bruno?
For a moment you did. Congratulations.
Thank you. I'm so proud.
But it's actually so interesting, everything that you said right now, and this whole conversation just got me thinking. Not once did we even touch on the merits. And it's a conversation that I had with some of my clients the other day, where they called me up and immediately started on the merits. We need to claim. And we've touched on this before, how, especially as lawyers and seasoned attorneys, that, looking at cases, it's not just about how good your case sounds. It's not an American TV show where anything goes, as long as you have Alan Shaw arguing the case and it sounds, and he sounds incredible. I mean, I love James Spader to bits, but I mean, we've South African courts, it wouldn't work. I've seen our judges, I've seen our opponents, that should just not fly. And even the way that we approach this question, not once did we even go, oh, but is it fraud? I mean, you mentioned the onus, maybe the difficulty, but I mean, there's just so much to our law. And all of these things, just so the viewers understand as well, this isn't unfair. It's not a question of, oh, but, shame, poor guy. It is a shame. And unfortunately, these laws are created to create an equilibrium for South African society. And there are certain exceptions to the cases that fall on either side of this equilibrium. And these are the very unfortunate cases. But the reality is, you do still need laws to guide us and guide this equilibrium, make sure that the majority, the 99%, are catered for. So 3 years is there because why 6 years? 6 years later, a person tries to institute a claim, you've got nothing. I mean, if it's financial, after 5 years, you start throwing things away because SARS doesn't need it anymore. So if a person comes and tries to claim something from you 6 years later, you've thrown away all your things. I'm actually a big critic of SARS's ability to audit someone past the 5 years, because they've done it to my clients before, and then all of a sudden, clients are looking for historical records from 10 years back, which they were told they wouldn't have to keep. Yes. So that's why. So we always need to understand it from both perspectives. Unfortunately, there are casualties in this, and it is sad.
Oh, thank you, Bruno. Thank you, Cilna, for that information. That's actually, I didn't know about that, and I'm sure a lot of viewers as well. So brilliant to hear this wealth of knowledge coming from you guys. Our next question was asked by an individual who's selling his home, and he states that he had made an extension or an addition to the original structure of that home. The purchaser now, however, is demanding certain compliance certificates with respect to this addition and extension to the home. That being a certificate for waterproofing and a plumbing certificate. The viewer says, look, he's known about compliance certificates for electricity and for gas, but he's never heard of anything along the lines of waterproofing and plumbing. So I think the question is this a demand that the purchaser can make? Is this even lawful for him to make that demand? I think we'll throw this through to Bruno and then to Cilna afterward.
Cool. So this is a very much a conveyancing question. It's very regulatory in nature, and it is the sort of things that conveyancers deal with on a day out basis. But from so obviously from my experience, we've never really had much disputes or commercial issues regarding certificates of compliance. But from my knowledge, every specific authority requires different compliance certificates, right? Now, there's a logic behind this. So obviously electrical installations are throughout. It's a national thing. So you need to make sure this house isn't going to burn down. So before you even market the property, you should have an electrical installation certificate in place, right? Now, this is in terms of specific legislation. So the Health and Occupational Health and Safety Act, right? Plumbing is an interesting one because no one knows about it. So I actually came across this simply when I was doing a rather complex OTP. In Cape Town, one of the bylaws requires plumbing certificates. And my understanding of this is because when you buy the coast, obviously with salt water, the corrosive nature of that type of water, and with the piping and the humidity, you may find that the pipes inside houses degenerate faster than inland properties. So plumbing certificates may be required, but remember, this isn't a purchaser opting to get whatever he wants. This is something that's required by legislation. If the purchaser wanted this and it's not required, he should have put it in the OTP and said, listen, I don't care what anyone says, I want a certificate that it complies. That's fine. So you can enforce it contractually if it exists in the contract, but you can't enforce it in law if it's not in the contract, because unless you live in Cape Town, for example. Waterproofing, never heard of that. I've never heard of certificate of compliance. It's not something serious enough that I feel would require a certificate. The only other one I know of is Beetle and wood borer certificates, and that again is coastal regions. Not inland, and it's for the very same reason. It's where you find the infestations, so you wouldn't do it in areas where there aren't any infestations and the risks aren't there. So yeah, I hope that answers the question.
Oh, thank you, Bruno. Cilna, if you want to add anything to that as well, Bruno's.
I have nothing.
Okay.
I can just say, clearly we are Joburgers and we don't know about weird things like water and stuff. Like, we don't have that. We have like dry places and nothing funny. So no, I have nothing.
Okay. So we should have like criminal certificates of when the last break-ins were. I think that's a thing. There should be, yeah.
It could very well be. Well, don't say that if we talk about rentals, because that's always my biggest thing to try and explain to tenants. Your landlord's really not responsible when somebody broke into your place, but I digress completely. But no, I hear you. Maybe that would be cool. No break-in certificates.
And pollution certificates, but yeah.
And loud neighbors.
Yeah.
I love that you guys just threw all of these in there as well. Guys, I'm going to ask this question. Maybe it's something for us to ponder about going forward, for the following weeks. But as quickly as you can, with the limited time that we have left, we have a viewer who's very worried about expropriation without compensation. It's a very real prospect that could happen in the next couple of years. We don't know what the political climate would look like. And he wants to know, is it worth buying now? Is it not? Do I have to wait for this? Is it going to happen? Is it not going to happen? Cilna, what do you think?
So glad I get that one, because I've actually done an article about 2 years ago. Remember, this was all the rage. 18 months ago, everybody was like, Section 25, Section 25. And Section 25 and Section 26 of the Constitution, obviously, that's what we practice. That's what we do. So Section 25 and Section 26, obviously, very dear to my heart. And I really delved into this in a lot of details. So I think one of the biggest things that we need to appreciate is the moment everybody was expropriation without compensation, and yay, then COVID came in and everybody's like, what? Section 25, what now? And everybody's over it. And nothing actually stopped. And I think I'm going to say this, I'm going to try and be diplomatic, but I'm actually going to be super blunt about it. If you follow social media and Huisgenoot, You Magazine, hypes, die keer, nee, die beeld, die rapport. Now I'm naming all the Afrikaans ones, and that's not what I mean. But what I'm saying is, if you follow hype, you will be hyped up. And I promise you, it's beautiful. It's much more entertaining to be hyped up than not. Actually, it's such a funny thing. My boyfriend looked at my Instagram feed the other day, and he's like, you have a bunch of Yorkies and stuff on your Instagram. What is wrong with you? And I said, well, on both Instagram, Facebook, all my social media stuff, I simply, if somebody posts something political in nature or something negative, I am going to unview your stuff, because I prefer not to have any negativity in my life. And why this is relevant to the expropriation without compensation conversation is, if you understand the law, if you understand how legislation is made, if you understand the process that an act has to go through to be amended, the amount of public input that is required, they actually sit there, the parliamentary committees must listen to every single thing, and they do. I am closely involved with the parliamentary committee for the that works on the Rental Housing Act, so human settlements. And I have seen the Rental Housing Amendment Act going from amending the term landlord to a more gender neutral thing, because they said landlord's not gender neutral, after public input, sticking to the term landlord. I have seen this actually, not Facebook post somebody with a mic and a camera.
Sorry, Cilna, what were they going to change it to? Landowner,
which is wrong, and that's obviously why they didn't. Yeah. But I know that happens, and you know as well. Very often we get legislation changes that pass, but that was because the majority of the country decided on that. Now, I don't know how to break the news to you, but we live in a democratic society. This means everybody has input. So if you use your input in drama on social media, it's falling on absolute, can't help you with anything ears. It's unfortunately not deaf ears. They're going to share the living daylights out of it and cause drama and harm what? Our own economy. It is silly, guys, to be worried about something that is factually not correct. So the viewer that asked this question, thank you so incredibly much, because you're asking the right people in the right forum without causing drama or chaos. You're asking a question. And the answer is, I do not know where we are heading with the legislation. The amendment of Section 26 of the Constitution isn't our problem. The amendment of the Expropriation Act will be the problem. So just in me saying that, I think I'm making a few people say, huh? We don't care about the amendment of Section 25. That doesn't affect us that much. An amendment to the Expropriation Act might, but we've already seen the draft legislation on that. It's not something that could happen and could bite us in the face. We know what everybody is planning. We know what's on the cards. And what's on the cards is unused, yellow, agricultural land are definitely up for potential expropriation without compensation. We are not there yet. That stuff that you see on social media, sorry, Chris, you said quickly, I'm not quicklying this one, sorry. But, and I'm not copying that, you see, this is my thing. I'm very passionate about this, you didn't notice. But there was this rumors about people will just invade your house. That's not on the cards. Yes, it happened. I know it happened in Achman, what's that place? Hermanus. And there was another one. There were a few, even here in Windsor, we had a bit of a attempted land grab. But what was the end of that, guys? Go back to the Hermanus story. Go back to that and see what happened. Immediate, urgent interdicts. Bam, 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 bam. That is what we have. We have a court system protecting the right of the owner. Yes, an eviction is a painful, long, costly process, but you have that remedy and the court is behind you. Yes, we're going to see expropriation without compensation. I don't doubt that at all. But we're going to see that on unused agricultural land. So my advice is buy property now. And if you own a piece of agricultural land that you are not using, try and sell it now. If you can't sell it, talk to a firm that understands how agricultural land works at this stage. Sell it on an installment sale agreement, something different. Get rid of your agricultural land that you are not using, or start using it. Rent it to an upcoming farmer. Guide him, help him, so that land can be used. And please, guys, stay away from drama, because this is what's killing our country. We need to look at the positive side, and we need to look at where we can uplift and help each other. And we need to really drive our economy instead of killing it with unnecessary drama. That, guys, if I had a mic, would have been
nice. Nice.
Nice. Bruno, 2 minutes or less, you want to add anything? Or
she just did a mic drop. I can't add anything.
That's true.
That's just rude.
There's no mic to hand over to you. Cilna threw it away.
It's on the floor.
No, but thank you so much, Cilna. Thank you so much, Bruno, and to the viewers who tune in every week to listen to you guys, and with all the wealth of knowledge that you bring. I hope that you guys will have a blessed week going forward. Please, the viewers, drop your questions down in our comments or on the page itself, and we definitely will get through to them as we did today. Cilna, tot ziens, Bruno, ciao bella. Cheers, everyone. Goodbye.
Yes.
Bye-bye.
Bye.